Well, I'm going to go ahead and get started. I know that there may be some people drifting in a little bit late because we had some confusion about precisely the venue. So we'll allow that to happen while I have the great honor of welcoming. It's a great honor and a pleasure for me today to introduce my former colleague, my longtime friend, and current ambassador, Beth Van Schaack. Um, Forgive me, I keep saying it the Dutch way.
I
I
was
know it's
impressed. You're flexing. You're flexing out.
it's a reflex. Ambassador Van Schaack is the State Department's ambassador at large for global criminal justice. And in that role, she advises the Secretary of State and other department officials on issues related to the prevention and response to atrocity crimes, including genocide, crimes against humanity, and war crimes. Maybe also now a little bit of dabbling on the crime of aggression. Before that, Ambassador Van Schaack served for many years here at Stanford as the Leah Kaplan Professor of Human Rights at Stanford Law School, where she taught courses on international human rights, international criminal law, human trafficking, and she also taught a policy lab on legal and policy tools for preventing atrocities. And I'm going to try to buttonhole her afterwards about a project that I'm about to start on that is aimed at trying to collect information about human rights abuses underway in Iran. Um, Ambassador Van Schaack also served as the interim director of our International Human Rights and Conflict Resolution Clinic. And if I recall correctly, she was also visiting or affiliated faculty here at CSAC, at the Center for International Security and Cooperation. Ambassador Van Schaack left us for a time at Stanford Law School during the Obama administration to serve as the deputy to the ambassador at large for war crimes issues, the job that she basically now serves in. She began her academic career at Santa Clara University Law School, where she focused on international human rights and international criminal law, but she's long navigated this pathway between academia and government service. And she's also been a member of the US Department of State's Advisory Council on International Law. I recall when she served as the academic advisor to the US interagency delegation to the ICC, the International Criminal Court Review Conference in Kampala, where the definition of the crime of aggression was finalized. Earlier in her career, she was a practicing lawyer at Morrison and Foerster. She was also at the Center for Justice and Accountability, a San Francisco-based non-governmental organization where she was also for a time acting executive director. Her career in international criminal law began actually when she worked at the Office of the Prosecutor of the ICTY, the International Criminal Tribunal for the former Yugoslavia. We may have been in The Hague at the same time,
yeah.
Although we were not partying together in those days. That's only happened since. Ambassador Van Schaack is a prolific scholar who's published numerous articles and book chapters, of course, on international human rights and justice issues. And she also served from 2014 to 2022 as executive editor for Just Security. For those of you who don't know it, it's one of the leading blogs on international law issues, particularly with respect to international security and international human rights issues. And her book, Imagining Justice for Syria, was published by Oxford University Press in 2020. Ambassador Van Schaack earned her BA here at Stanford, her JD at Yale, which is sort of the one black mark on her otherwise outstanding CV, and her PhD in law from Leiden University. Please join me in welcoming Ambassador Van Schaack back to Stanford. We'll give her the podium and she'll deliver remarks for some time, and then we'll come back here and we'll open it up to your questions. So please join me in welcoming Ambassador Beth Van Schaack.
Thank you so much, Alan, and thank you to CSAC for welcoming me back. It's really great to be here, and it's lovely to see you. I look forward to the conversation. I'll give some brief remarks about some of the priorities that my office is dealing with now, including with respect to Ukraine, and then I'm really looking forward to our questions. So I am the 6th ambassador at large for global criminal justice. This was a position that was created by Madeleine Albright to serve as a point of contact with the International Criminal Tribunals, and our mandate has grown ever since. I was sworn in almost a year ago today, actually, in this position after going through the Senate confirmation period. And it's really been a time of extraordinary challenges, but also opportunities, I think, in the field of international criminal justice. So my job and the mission of my office is to advise the various components of the US government on the development and execution of policies around atrocities prevention and response, and particularly how to redress atrocities through justice and accountability. And to this end, we engage in international diplomacy and various multilateral fora to build partnerships with like-minded states. And I am able to deploy a very small programming budget to help capacitate this work around the globe. I'd like to speak today about some of the particulars of the Biden-Harris administration's efforts to combat atrocity crimes happening around the world and to ensure accountability. Of course, given recent events, I'll give particular emphasis to Ukraine, but I really also want to focus on other regions of the world, given the many calls for justice that are being made and somewhat of a sense of selective justice, maybe, with respect to the high degree of attention that's been given to the Ukraine conflict. I hope that these remarks will help to map out for everyone the sort of state of play on the multilateral field of international justice and some macro observations in that regard. So first, what we're seeing is that the world has never been more united around the imperative of justice and accountability following the commission of atrocity crimes. This newfound consensus has been very much inspired by the situation in Ukraine, but we're seeing it reverberate out with respect to other situation countries as well. The system is increasingly decentralized and multipolar. So while the ICC, the International Criminal Court, remains almost sort of a hub of the ecosystem of international justice, there are justice efforts happening in other international, hybrid, and domestic courts around the world. And I'll talk about some examples. We're also seeing a real deepening of state practice around prosecutions for international crimes. This is inspired in part by the fact that many states have joined the International Criminal Court Statute, the Rome Statute, and incorporated those crimes within their domestic codes. They've also created specialized war crimes units. Those units are increasingly interoperable, and they're working together to advance cases in their national courts. And also, norm entrepreneurs, many of whom are in this room, continue to explore and develop new initiatives to ensure comprehensive accountability for international crimes in response to Russia's unjust and terrible invasion of Ukraine, but also in other situations. I want to say at the outset that I hope my remarks will inspire a robust conversation amongst us in the spirit of critical inquiry. And nothing I say should be considered a full-scale support for the US government for any particular proposal. So I'd like to be able to speak freely if I can. So at the risk of understatement, it should be obvious that President Biden has taken a very different approach to international law than his predecessor. Rather than abandoning multilateral institutions, the Biden administration is reinvigorating these alliances, ensuring that they have strong and effective leadership, and working towards, with them and through them, to strengthen a rules-based international order. Rather than embracing tyrants and autocrats, the Biden administration is pursuing an affirmative agenda for democratic renewal and will be hosting the next Summit for Democracy in a couple of weeks. Rather than shrugging at or denying planetary crises, the Biden administration is rejoining and taking steps to strengthen international efforts to tackle the greatest threats that are facing our globe. This new approach to international affairs also carries over into international justice. So prior to my appointment, the Biden administration launched an early interagency process that was convened by the National Security Council to repair the damage that had been done to the relationship between the United States and the International Criminal Court, and to acknowledge the prior missteps of the Trump administration. At the time, I was sort of bummed that I was not in government while this was happening, because this is one of my passion projects. But in the end, I am actually at peace with the fact that I wasn't there, because of what it meant was the entire government got to that point without a person like me in the role that I'm in. And so this was very clearly a consensus position across government. As part of this process, Secretary Blinken pulled down the sanctions that had been issued against former prosecutor of the ICC, Fatou Bensouda, and one of her deputies, and admitted that those sanctions should never have been imposed. As an aside, I should note that there is an effort afoot on the Hill. Representatives McGovern and Castro have introduced amendments to IEPA, which is the underlying statute that allows us to do the various sanctions regimes that we do. And it would disallow sanctions for individuals who are working to promote international human rights around the world. That is still in draft form. It's only a bill, but it'll be interesting to see if that is able to move forward. The new stance of the court, of the United States towards the court, was announced at the Assemblies of States Party meeting in 2021. This is a gathering of members of the ICC and also of observer states. Our Undersecretary for Civilian Security, Democracy, and Human Rights delivered those remarks and indicated that it was a new day with respect to the relationship, that the court has an important role to play. It's an important component and player within the larger ecosystem of international justice. And there's much that we can do, even as a non-party state, to support the work of the court going forward. So when I assumed my post, I inherited a very clear mandate that I was to advance justice wherever I could, including potentially with respect to the International Criminal Court. And although we are a non-party state, there's much that we can do to support the court. And I thought I would outline some of the various ways that we have done, various things that we have done in order to support ongoing investigations and prosecutions before the ICC. So as my first trip, the first thing to think about is sort of multilateral and diplomatic support for the court. On my first international trip as ambassador at large, I had a very interesting itinerary where I started at Nuremberg, which was really where this field began. Then I went to Brussels, to Geneva, and then I landed in The Hague, which is where the ICC is located and is now the center of international justice. And the point of this trip was to convey this new approach to international justice, to convey that we want to repair our relationship with the ICC, and including with respect to Assemblies of States Parties members who were quite disappointed by the stance that the Trump administration had taken toward the court and were not afraid to tell us so. We also are looking for ways constantly to assist the Office of the Prosecutor with their investigations. So with respect to the Darfur matter, for example, the court has just now commenced the first trial of a senior member of the regime of Omar al-Bashir. This was with respect to the crimes against humanity and genocide committed in Darfur. As many of you may recall, during the administration of George Bush, the State Department launched a very important population-based survey within refugee communities in some of the neighboring states around the Darfur state in a goal to getting their collective experience of violence under the Janjaweed military and militia, and then the formal militaries of Sudan. This generated really important data that undergirded President Bush's determination that a genocide had been committed and was underway within Darfur. And we're quite hopeful that some of this data will be useful in the ongoing prosecutions before the court. At several visits to The Hague, I have now met with all of the various organs of the court, expressing our support for their work, announcing our willingness to engage, and soliciting ideas for how the United States can better support and advance the court's work. I've held a number of bilateral and multilateral meetings with members of the Assemblies of States Parties, including hosting an event with the GRULAC states, the group of Latin American and Caribbean states, and also the African state parties, in order to understand their perspective regionally on the system of international justice and their relationships with the court. I've also been able to appear before the Organization of American States to express US support for the Venezuela investigation, which is now underway, and also to express admiration for the region and the way in which it developed many of the transitional justice tools that we see now being deployed around the world in situations that are emerging from armed conflict or from situations of repression. They're very much the model and the progenitors of many of these mechanisms that we're now seeing applied across the world. And my office works in many of these situation countries to try and strengthen those institutions. We have hosted the new prosecutor, Karim Khan, several times in Washington, where we've been able to set up high-level interagency meetings across government and also enable him to speak with specialists in many of the situation countries in which he's working, such as Darfur or Ukraine. On his first official visit, Karim Khan and I met with Senator Lindsey Graham, who's a leading Republican, as you will know, who had just issued a unanimous resolution in support of the court's work in Ukraine. And we met with him. He expressed his admiration for the work of Karim Khan and was asking for very concrete suggestions of what more the United States could do to enable that investigation to be successful, particularly with respect to high-level perpetrators within the Russian Federation. Senator Graham went on to sponsor a number of really groundbreaking pieces of legislation, not only expanding the ability of the United States to prosecute war crimes in our domestic courts, but also loosening some of the restrictions that had been placed on our ability to cooperate with the court under the Bush administration. And so now it's a new world when it comes to the ability to provide assistance. One of the provisions that was amended is with respect to investigative activities within the United States. There had been a full-scale ban on those investigative activities happening here. So if there was a witness, for example, in the United States, that person would have to be flown out of the United States in order to conduct a substantive interview of that person. That was just silly. And so that has now been removed with respect to the Ukraine matter. And we're hoping that that will build some practice that will enable us to allow those sort of investigative activities for all of the open situations that the court is looking at. On the bilateral front, we also work with ICC situation countries in order to encourage their cooperation with investigations happening at the court. So for example, with respect to Sudan, in our messaging, we are constantly emphasizing that they have obligations under Security Council Resolution 1593, which referred the matter to the court back in the day. They need to permit ICC teams to come and investigate, to meet with survivors, to meet with victims' communities. They need unimpeded access to key witnesses, and witnesses need to be able to be issued visas to be able to come and go. And also the goal is to facilitate a field presence within Sudan so that the ICC can have investigators on the ground in order to meet with court officials. I've also begun visiting ICC situation countries. So my first trip to Africa as ambassador at large, I visited the Central African Republic, where there is a grand experiment in hybrid justice underway. We now have cases happening at 3 levels: in national courts, both civil courts and military courts, in a hybrid institution, the Special Criminal Court for the Central African Republic, and then the ICC also is exercising jurisdiction over the matter within the Central African Republic. And it was amazing to meet with these international and national staff who are working at the Special Criminal Court, how they're able to meet important milestones, make important progress, even with having very few resources and virtually no international attention at all on what they're doing. They recently delivered their first verdict with respect to the 3R rebel movement that stood accused of committing a number of massacres in several villages during the armed conflict there in 2019. We have supported a continuous congressional appropriation for the Special Criminal Court. It's now totaling $6 million. This goes towards witness protection issues, towards sort of technical issues, building out the technical capacity of the court, and also forensics with respect to mass graves that have been found in connection with some of these massacres. We have encouraged cooperation between the Special Criminal Court and the ICC. That was a little shaky in the early days. That now has rectified itself in a way that is now quite fruitful. And to the point in which the ICC has, the prosecutor has announced that he will not be issuing additional indictments with respect to the Central African Republic. So it's a real vote of confidence in this new hybrid model that it's able to do this work itself, bringing justice home within the Central African Republic rather than having it happen abroad in the Hague. The United States has also contemplated potential additional Security Council referrals. Of course, the Security Council is now paralyzed given the acrimony with respect to Russia and China's apparent interest in sort of hiding under the skirts of Russia and exercising its own double veto. So at the marking the 5-year anniversary of the 2017 genocide in Myanmar, Secretary Blinken announced support for measures by the Security Council exercising its peace and security mandate to consider a referral of the situation in Myanmar to the court. That has not materialized yet and would likely be vetoed by China in this case, potentially, but also I imagine by Russia as well. But it does express support in the court and also was very well received within victim and survivor communities across Myanmar. This followed upon a very moving speech by Secretary Blinken, wherein he announced the United States determination that crimes against humanity and genocide had been committed against the Rohingya community. And that determination has led to a number of inquiries around the globe where other parliaments have made their own determinations to this respect. We remain strongly committed to the people of Burma. We are supporting a mechanism that was created by the Human Rights Council called the Independent Investigative Mechanism for Myanmar, the IIM. This is sort of a prosecutorial office that is working as a clearinghouse to gather evidence, not just with respect to the genocide against the Rohingya, but also violence after the coup with respect to peaceful protesters and other ethnic and religious communities within Myanmar. At the United Nations General Assembly High Level Week, I was able to announce another $1 million donation to the IIM. This one is focused on witness protection, not just sort of vulnerable percipient witnesses who obviously need protection and are often a linchpin of a case being successful before a domestic or an international court, but also insider witnesses. These are individuals who have really unique perspectives on how violence unfolded, who was ultimately responsible, how decisions were made, what the order of battle was, et cetera. And they need to be supported even while we may acknowledge that they were once part of an apparatus of violence. And so my office has taken on an initiative to think hard about how to create a multilateral system to do witness protection, both types of witnesses, percipient, vulnerable victim witnesses, but also insider witnesses. The first $1 million grant that we'd given to the IIM went to strengthen their capacity to do open source investigations, which is the sort of new field of international criminal law investigations. We have also shared information with the Gambia, which is a West African state, quite tiny, that has brought suit against Myanmar under the Genocide Convention before the International Court of Justice, calling them out for failing to adhere to their obligations under that treaty because they have ratified that treaty. I was able to visit Cox's Bazar. I met with, which is in Bangladesh. I met with some of the survivors who went to The Hague and were able to testify and provide support for the Gambia in that particular effort. The International Criminal Court has also opened an investigation, not because Myanmar has ratified the treaty, but because neighboring Bangladesh has ratified the treaty. And the court has determined that at least some crimes were consummated on the territory of a state party, in this case, Bangladesh. And so that gives it jurisdiction at a minimum over crimes of enforced deportation across an international border. And I was able to meet with some of the individuals who will be giving testimony in the ICC matter as well, if that ends up moving forward. It was incredible to speak with survivors in Cox's Bazar. This is a refugee camp housing upwards of 1 million people. You may have seen they've had 2 terrible fires recently. They're living in very unsettled circumstances, incredibly densely populated. Ordinary refugees with whom I met asked me about what was happening at the ICC, what was happening at the International Court of Justice. They are following these justice initiatives extremely closely. There have also been some cases that have been opened and investigations that have been opened in national courts. So Argentina was the first using universal jurisdiction to open an investigation into the crimes that were committed in a particular village. There are 6 women who will be hopefully traveling to Argentina. I visited Argentina to work with, to meet with the prosecutors there and the judges who are hearing these cases in order to think about how we might facilitate travel for individuals who've never been on an airplane, who have no travel documents, who have to leave a refugee camp, travel to Latin America, give their testimony, and then somehow make it back safely and not be subject to retaliation if they do go back to their homes in Bangladesh. The United States has also worked to help support the execution of arrest warrants that have been issued by the court and other courts around the world. We have reinvigorated our War Crimes Rewards program. This is a program that my office administers. We can issue rewards for up to $5 million for information that leads to the arrest, capture, transfer, or conviction of individuals who have been accused of war crimes, crimes against humanity, or genocide by either a national court, a regional court, or an international court, such as the International Criminal Court. We have a number of designations currently in the program, including 4 outstanding Rwandan genocidaires and Joseph Kony, who's the messianic head of the Lord's Resistance Army. We're also looking to make additional designations in the near future. Congress recently amended this legislation and gave me the authority to issue rewards in cases in purely national courts. It had been somewhat ambiguous before, and now we are able to support international crimes prosecutions that are happening in national courts and issue rewards for individuals who stand accused. Now, this is a snapshot of our relationship with the International Criminal Court, but there are many other institutions now operating. As I mentioned, the system is increasingly multipolar, and we are looking for ways to advance the work of these organizations as well. So there's the Kosovo Specialist Chambers that are prosecuting individuals who stand accused of committing crimes during the Kosovo War. Many of these crimes fell outside of either the temporal or geographic jurisdiction of the International Criminal Tribunal for the former Yugoslavia. So a Kosovo court is sitting in The Hague. It's a national court. It has international elements, so it's a hybrid court, sitting in The Hague hearing these cases. The big case, former President Thaci, is starting in less than a month at this point. There are very acute witness protection concerns, and so we're trying to work on that front as well. And normally the United States appoints a chief prosecutor. The former chief prosecutor has just been asked by Attorney General Merrick Garland to lead the January 6th investigation. So that vacancy is now open. So we have been entertaining applications to refill that position. And that person will be seconded from the State Department to fill that position. In addition to the IIM, there's also the IIIM, which is the Independent International Investigative Mechanism for Syria. You may recall that there was an effort to refer the matter in Syria to the International Criminal Court. Russia vetoed that effort with China in tow. And so the General Assembly created a proto-prosecutorial investigative body called the IIIM that is now operating, collecting information from grassroots organizations, from governments, from interesting new civil society efforts of kind of private investigators who are collecting documents within Syria, exfiltrating those documents, and then making them available to prosecutors around the world. The IIIM's work has been instrumental in enabling some universal jurisdiction cases to happen across mostly Europe, where a number of perpetrators have been identified, including very high-level figures within the Assad regime who have been indicted for war crimes and crimes against humanity. There's also UNITAD, which is a similar body created by the Security Council to support potential prosecutions with respect to Daesh in Iraq. And so we do a lot of work with UNITAD, and particularly when it comes to supporting their investigations of violence against the Yazidi community. We're a member of the Sri Lankan Core Group in the Human Rights Council. This is a Geneva-based body that often deploys commissions of experts, fact-finding missions, et cetera, that maybe are not as robust as some of these investigative mechanisms, but they're still able to collect information and make that available to accountability efforts around the world. National transitional justice proceedings. As I mentioned, my office also advises on how the US government can support transitional justice wherever it's happening around the globe. This often involves educating our embassies who have to determine what our policy is going to be towards a truth commission or towards an amnesty that might be being contemplated, how we might support a domestic prosecution that's going forward within a national court. So I visited Ethiopia during, not after the cessation of hostilities agreement, but during a 5-month or so ceasefire period that had opened up the political space to start to speak about what transitional justice would look like for Ethiopia, not just with respect to the war in the north in Tigray, but also with respect to grievances that have been very long-standing for many years and that have fueled cycles of violence for several decades. We hope to be a partner with respect to transitional justice to ensure that initiatives are fair, are transparent, are inclusive, and are balanced. Members of my team are actually in Ethiopia right now with Secretary Blinken, having a whole series of discussions about what the vision for transitional justice is and how we can be supportive. The cessation of hostilities agreement that was achieved in November contains a very important pledge by all parties to that conflict that they will commit to a transitional justice process that includes accountability. And so the question now is, what does that look like? How do we build that out into a transitional justice program that respects the various pillars: truth, justice, rehabilitation of victims, and guarantees of non-repetition? In this regard, we're also working very hard through our embassy in Colombia, which is engaged in an extremely sophisticated transitional justice exercise for almost 50 years of armed conflict. There's a number of different elements and institutions. There's a truth commission, there's a commission for the disappeared, and there's the HEP, which is essentially a justice mechanism that has the ability to issue sentences for individuals that may not amount to jail time, but nonetheless would constitute a deprivation of liberty and an obligation to give back to the society. So it's an interesting effort to create a sort of quasi-amnesty that brought people to the negotiating table and enabled that conflict to come to an end, but while still respecting the rights of victims for some measure of justice and also creating an opportunity for reparations for victims. I will be heading to Colombia next month in order to meet with all of the various institutions. We are considered a co-sponsor of one of the chapters of the peace deal. This is with respect to ethnic minorities, in particularly individuals of African descent, who in some circumstances were specifically targeted during the various conflict periods. And so our goal is to see sort of robust implementation of that chapter of the peace arrangements. I've also visited the Gambia and Liberia, both of which are at sort of the same point in their transitional justice pathway, although Liberia is sort of lagging 10 years behind. Both have had very successful Truth Commission processes that were very well respected, that were inclusive. The Liberian Commission, I think, took something like 30,000 testimonies. I met yesterday with the principal statistician of the Human Rights Data Analysis Group, which did all of the statistical analysis in order to show which particular armed groups were most responsible for violence, given the kind of records that exist with respect to the 2 consecutive armed conflicts within Liberia. Nonetheless, implementation has lagged. That Truth Commission process in Liberia happened 10 years ago, and virtually nothing is done with respect to the very cogent recommendations that were issued by the Commission. The Gambia has more recently had a Truth Commission process. They too now are on the verge of implementation. I was in the Gambia, I met with the president. He specifically pledged to seek a hybrid court. He has now made that pledge public. They have started negotiations with ECOWAS, which is the regional economic integration body that also has a court associated with it within West Africa, to be a partner in the creation of a hybrid institution to look at violence during the Jammeh regime. Just a little footnote, we actually have a universal jurisdiction case pending here in the United States in Denver. A member of Jammeh's Junglers, which was essentially a death squad that he sponsored, overstayed a visa and sort of disappeared, and was later found by members of the Gambian diaspora community who are here. They contacted law enforcement, who've now opened an investigation and now are seeking to prosecute him under our torture statute, 18 USC 2340, which provides for present-in jurisdiction over individuals accused of committing torture. So because he's present here in the United States, it doesn't matter that the crime happened abroad, that the victims were Gambian, that he is Gambian himself, and that all the events relevant and much of the evidence is actually in Gambia. We have the power to bring that case, and that case is now moving forward. We also work quite a bit with civil society organizations, and my programming money is generally devoted to supporting and capacitating civil society. These are human rights advocates that are trying to push for justice processes in their local communities. So there's the International Accountability Platform for Belarus, which is a coalition of Belarusian organizations looking for ways to document human rights abuses and potential international crimes, and trying to think creatively about how to push justice there, including with respect to Belarus's unhelpful role with respect to the war in Ukraine. We also have a project in South Sudan training advocates who are waiting for the political space to open up there to be able to implement some of the promises that were made in the Juba peace agreements with respect to a hybrid court and other transitional justice elements. We also have a new initiative, which is a rapid reaction team, which is a consortium of 5 NGOs, one focused on witness and victim rehabilitation, one focused on justice, one focused on technical assistance with respect to transitional justice, an academic institution, et cetera. We can deploy this consortium very quickly when there's an initiative ongoing or an opening presents itself where a justice pathway is being considered. And we can send these experts in to either work with civil society or work with the government themselves in order to create a fair and open and inclusive process. Much of this work involves utilizing to good effect new technologies. And part of the reason I'm here in Silicon Valley this week is I've been meeting with some of the big tech companies to think about the various ways their work intersects with my work. And we can think about this in multiple ways. So on the one hand, there's questions of information that may be evidence that's available on these platforms. How does that information get to justice actors, particularly justice actors that are not ordinary US courts where you have a natural sort of subpoena process that you can utilize? How does the IIIM, that is focused on Syria, ask Meta for data that might appear or might have appeared at one point on Facebook? And so trying to facilitate those relationships and look for pathways for communication and cooperation is something that we are doing with respect to the tech community. We also have to think about risk assessments and the fact that these tech platforms have been used to foment violence, whether it be true incitement to genocide or incitement to other international crimes, or simply being used to organize violence or to spread hate speech, et cetera. And so what role do these platforms have in terms of preserving some of that information, even if it violates community standards or violates their terms of service? It should be kept available for law enforcement, including potentially international trials. And so those are some of the conversations that are happening. And finally, with respect to witness protection, if they have do they have some sort of a duty to warn if they have some indication that witnesses are under assault? And we have seen this with respect to Kosovo, where witnesses' names have been published that are supposed to have been kept anonymous, and that those names have then been disseminated through various platforms. And how can some of these justice institutions work with these platforms to take that information down in order to protect witnesses, and also then lay the groundwork for potential charges for interference in the administration of justice, tampering with witnesses, et cetera. This brings us to Ukraine, and I'll use the remainder of my time to talk a little bit about what we're doing here. So obviously, Russia's war of aggression is a manifest violation of the UN Charter. We have mounting evidence that these acts of aggression are being committed through the commission of systemic war crimes and crimes against humanity. Vice President Kamala Harris recently announced at the Munich Security Conference that we had done an internal process and had determined that the standards for crimes against humanity have been met in virtually every region in which Russia's troops have been deployed. This includes deliberate, disproportionate, and indiscriminate attacks on the civilian population and elements of the civilian infrastructure, and also efforts to cover up these offenses. This includes attacks on protected persons who are in Russian soldier custody, Russian forces custody, including civilians, but also prisoners of war, individuals who might be entitled to prisoner of war protections. And we also have seen the construction of a vast transnational network of filtration operations. Evidence, research that we sponsored has proven that much of this infrastructure was in place prior to February 24th, so this was extremely premeditated. Individuals who go through these filtration processes face one of three fates. One, they may be deemed to have passed, in which case they might be entitled to return home or at least to continue to reside in Russia-controlled areas. If they don't pass, they might be subjected to further interrogation, which can include torture. And then they may be subjected to deportation, often to very far regions of Russia. And third, they may be subjected to long-term detention, and individuals have been disappeared who have been put through this filtration process. There's also mounting evidence that children are being put through a filtration process and being subjected to forcible adoptions within Russia, even when they have parents or guardians who want them back and who want to have access to them. All of the evidence that has been gathered in this regard makes it very clear that these are not the acts of rogue individuals or units, but rather these are, we're seeing really disturbing and consistent patterns across the entire battle space within Ukraine. And of course, some of these actions are also quite consistent with what we've seen from Russia and other places in which its forces have been deployed in Chechnya, in Syria, in Georgia. So the reinvasion last year, because of course Russia invaded in 2014, we should not lose sight of that, and all of the damage that it has wrought has really inspired an incredible number of responses within the international community to document crimes and then also to create pathways to justice. And so the US has been sort of plugged into many of these efforts. So the International Criminal Court is seized of jurisdiction. Ukraine consented to jurisdiction, and then 43 states referred the matter to the court, giving the prosecutor the green light to open an investigation. The New York Times just broke a story last week, or maybe early this week, I've lost track, indicating that the prosecutor may be poised to seek arrest warrants for two different crime bases. One, the abduction of children and these filtration operations, and the second being attacks on elements of the civilian infrastructure. So remains to be seen if those arrest warrants are made public and when that might happen. There's been a commission of inquiry created on Ukraine that we are able to support, and we helped stand that up in the Human Rights Council. The Organization for Security and Cooperation in Europe invoked its Moscow mechanism, which is sort of appropriately titled, although the name preceded the current invasion. This is also an investigative body. There's a human rights monitoring mission in Ukraine, and a number of European states have created a joint investigative team. This enables their prosecutors to essentially share information quite seamlessly. Otherwise, they would have to go through a mutual legal assistance treaty, which can take some time and involves, the injection of diplomats. And so in this case, prosecutors can just talk to each other and share information. The ICC prosecutor is a member of that JIT, so he is also able to have access to all the information that is being collected by the JIT members, which are generally the frontline neighboring states of Ukraine. A number of other European states and the United States are sort of participants in the JIT. We're not full-scale members, but we're trying to be supportive of its work. The United States has also intervened in a case brought by Ukraine under the Genocide Convention before the International Court of Justice, arguing that Russia is manipulating the concept of genocide in order to justify its invasion of Ukraine. And so we and another, I think, 23 or so states have intervened in support of Ukraine and in support of the arguments it's making that this is a misuse of the Genocide Convention. We've also created a program to support the Prosecutor General in Ukraine. This is essentially complementarity, the idea that the first line of offense in the justice realm should always be as local as possible. And so I received additional appropriations from Congress this year, $15 million, and I'm hopeful that I'll have another $15 million in the future to be able to support the Prosecutor General in his work as he brings cases in domestic courts. They have a war crime statute. They do not have a crimes against humanity statute. So most of these cases are going forward under a war crimes rubric. Some of them have been in absentia, but they do have custody of several prisoners of war whom they have evidence against, and those cases are moving forward. There's been, maybe 100 or so indictments being issued at various stages along the process. Our project deploys experts who are veterans from the world's war crimes tribunals to Kyiv and then into the field in order to work side by side with counterparts to enhance their ability to bring these cases? How do we prioritize the 77,000 potential incidents that have been recorded of war crimes since the war began the reinvasion began in 2020, last year in 2022? How do we think about conflict-related sexual violence, given the high degree of stigma associated with those offenses and the the unwillingness we often see of survivors to come forward? How do we do investigations and interviews in a trauma-informed way, so witnesses are not interviewed over and over again, but rather interviewed once and well, and that becomes the definitive statement? How do we prosecute the siege of Mariupol? Well, let's send the person who prosecuted the siege of Sarajevo down to Kyiv and to work side by side with that prosecutor. This is how we did it. This is the evidence we obtained. These are the charges that we were able to bring. This is what our project is trying to capacitate. We've been joined by the European Union and the United Kingdom, and so we formed an umbrella organization called the Atrocity Crimes Advisory Group that seeks to provide this advice to the Prosecutor General in Kyiv and then out in the field. We have a prosecution support unit that's sitting in Kyiv, and then we have mobile justice teams that are able to be deployed kind of almost instantaneously out to areas where potential war crimes have happened in order to cordon off the crime scene and to collect the potential evidence in a way that will adhere to international chain of custody standards and also provide the best evidence to be able to ultimately bring charges. We have also created a conflict observatory. And so if you're interested in the situation in Ukraine, I would really recommend their reports to you. This is an independent body. It's based at Yale. But the idea is to collect open source information. So satellite imagery that may be behind a paywall and so would not be available to sort of normal people, but also scrubbing social media sites, aggregating all of these data, and then putting out refined analysis of what these open source data reveal. So they've put out reports now on attacks on cultural property, on schools, on hospitals, on grain shipments. The most recent report is on the children, and they have evidence of 6,000 children to a very high degree of certainty. So they basically require 5 pieces of corroborating evidence before they will make a finding that 6,000 children have been taken from family members or have been kept in Russia, even if they were sent there initially, kept in Russia and are not in contact with their family members who do want them back and who do want to have contact with them. And that work is going to continue with these different sort of slices and perspectives on the conflict. Finally, we are getting our own house in order. As I mentioned, Senator Graham helped to co-sponsor amendments to our War Crimes Act. We now have present in jurisdiction over war crimes, which means that just like our torture statute, if a suspected war criminal is found here in the United States, we can prosecute them for war crimes, even if they're a non-national and their crimes were committed abroad and the victim is a non-national. So prior to this point, we were only able to prosecute if the victim or the perpetrator was a US person. There are probably some of those cases out there because there were a number of American citizens in Ukraine, including some individuals that have gone over to fight, dual nationals, people who have married there. We've got journalists, et cetera. But we now have a much broader jurisdiction. The Department of Justice has created a war crimes team. I traveled to Ukraine. My first trip to Ukraine was with the Attorney General, where he was able to announce the creation of WARCAT, War Crimes Accountability Team, a specialized group of war crimes prosecutors who will be using this new authority and looking for cases that might have some kind of a US nexus and thus could be brought in US courts. They also have an MOU with the Prosecutor General in Ukraine to be able to share information if any US type cases emerge such that we might be able to assert jurisdiction here. So I'll conclude because I want to make sure we leave time for questions. So while there's much happening on the international justice realm, it really only scratches the surface of the acute needs, and much more needs to be done to focus on the prevention side of this work. We did have established the Atrocities Prevention Board under President Obama. It remained alive, although in quite a weakened state under the Trump administration, and so now we're revitalizing that effort. That's hard work. We don't have great data, and this is where academics can be extremely helpful, but there's definitely more to be done on the preventative side. I have often described this as a new Nuremberg moment, just as the Allies after World War II got together and essentially created a system of international justice with the Nuremberg and the Tokyo Tribunal in the Pacific Theater. So too, it now falls to all of us to make sure that the international justice system responds in a robust way to what we're seeing with respect to the war in Ukraine and also around the world. We must ensure that all the principles that were championed at Nuremberg remain alive and are actually strengthened going forward. And as we all focus on Ukraine, and I'm happy to take many questions on them, but we also have to not overlook the growing perception of a number of states around the globe, particularly in the global south, that the concerted response in Ukraine stands in stark contrast to a much more limpid response that we've seen with respect to other areas, very inconsistent and very uneven. And so we have to engage seriously with these perceptions of bias and of selective justice and of double standards. And so all of us, I hope, will dedicate ourselves to looking for ways to plug into the system. And there's much that students can do with respect to internships and research, thinking about even non-lawyers understanding data science, data visualization. All of this stuff is the new frontier of international criminal justice. And so I look forward to your questions on where things stand and how you might be able to contribute to all that we're trying to do here. So with that, I'll close.
Well, my first comment in response to that presentation is simply, wow, what a staggering tour d'horizon. And I really, want to commend you for your choice of not beginning with Ukraine, right? Which is, of course, what we're all, or many people may be interested in, thinking about war crimes accountability for the first time. And yet it's been such an important issue in so many parts of the world for so long. And so I really commend you for doing that. Let me go ahead and abuse the chair's prerogative, as of course is customary, by asking the first question before I open it up. And it's the question that you've gotten a ton of times, and I'm sure you've expected it. But let's go ahead and ask it. And again, it concerns the U.S. position with respect to the International Criminal Court, more generally, which has been a contentious one. Of course, the United States is not a party to the Rome Statute of the International Criminal Court, as you know, and we've adopted a legal theory that says the court doesn't have the capacity, or should not have the capacity, to exercise jurisdiction over crimes of nationals of non-state parties, even if those crimes occur on the territory of states that are parties, right? And yet here in the case of Ukraine, when crimes are being committed on the territory of a state that has consented, we're enthusiastic about the notion of accountability for Russia. So I suppose my question is, in your role as ambassador for war crimes issues, to what extent are any of these issues open for being revisited or reconsidered within the United States government, or have we reached, have we gone as far as we can go on ICC relations? And of course, part of the reason why people like me ask this question is because we believe the U.S. position on the ICC maybe undermines U.S. authority on war crimes issues. But that's an empirical question of whether it does or does not, right? Conceptually, you would imagine, but does anybody care really that the United States has its view in terms of our relations with them on accountability issues? So I'd be interested in your thoughts on those questions.
Yeah, sure. So just one point of clarification, it's actually not a legal argument, it's a policy argument. There have been efforts to establish that position as a legal one, but it's never been conceded to have been a legal argument. It's a policy argument.
Well, isn't the position that the
here's the talking point,
may not, which sounds like
we have long-standing objections to the exercise of the court over the nationals of non-party states. That's the point.
Long-standing objection.
Yes.
Okay. But
there it is. It is there, and that objection exists. And it does make it more difficult to assist with matters that involve the nationals of non-party states like Russia. I think some of the arguments that get made is there's virtually no equivalency to a situation that might involve U.S. persons before the court. So Afghanistan is a member of the court, and so at a time there was an investigation open into international forces, including potential custodial abuses that had happened with respect to the war in Afghanistan. The prosecutor has now deprioritized that investigation and is focusing his attention on crimes committed by the Taliban and ISIS-K, which, we have argued is an appropriate use of resources there. I think the equivalency with respect to the Russia situation is really a false one. I mean, the only thing we have in common is that we're non-party states. This is a war of aggression, attempts at territorial annexation, and in fact, the de-Ukrainization of the world. We have a lot of kind of rhetoric to this effect. It's a war of aggression that's being committed through systemic war crimes and crimes against humanity. These are not the types of allegations that are ever issued against the United States. And there's zero prospects for accountability whatsoever within Russia. Whereas we have a very robust military justice system. Many may quibble with some of the outcomes and think it has not been robust enough and that it should have been more active, but there is a system and it works. And we had a system that looked at the situation of custodial abuses in Afghanistan as well. And so, complementarity at some point kicks in and says, you leave it to the national system to do the work, and there isn't a role for the international court. So, I think we're in a good position vis-a-vis being able to distinguish the current situation with respect to Ukraine and Russia with respect to any other situation where we might need to invoke this talking point again. What's important to mention is it's not a legal argument, it's a policy argument, but it's a policy argument that doesn't have much traction before the court or any actors within the court. So the Office of the Prosecutor has proceeded against individuals who are the nationals of non-party states, Rwandans, for example. Obviously, the Ukraine matter and the Myanmar matter. The Georgia matter involves a Russian citizen as well. It's been rejected by the pretrial chamber. It's been rejected by the trial court. And so, it doesn't carry much purchase, I don't think, when it comes to preventing the court from moving forward.
But on just this empirical point, is this a question and answer that you have in your diplomatic work? Do people come to you when you're traveling around the world, and do they say like, well, I know you're here to talk about justice, but why doesn't is this
The
something
question I
that you
get,
encounter in trying to make the case for
I
global
do.
international
I get
justice?
two questions. The one question is, why don't we ratify?
Yeah.
And the second question is, isn't it hard to help the court if you're not a party? And the answer to the first question is sort of obvious. There's a lot of treaties we haven't ratified. It's hard for us to ratify treaties. We don't generally subject ourselves to supranational jurisdiction on any front. We haven't joined many international courts that exist out there that are even many of our closest friends and allies have joined. Second, it's very hard to ratify treaties. There's a very high standard, being a law professor. And treaties that, the Convention on the Rights of the Child, we're the only sovereign in the world that has not ratified that treaty because we haven't been able to reach the necessary 2/3 majority. The Convention on the Rights of Persons with Disability, which is based upon the Americans with Disabilities Act, we're already in almost full compliance with that treaty. We still can't ratify it. So that's where we are. I often envision in my head a kind of quadrant, and across the top it says, are you helpful? And across the side it says, are you a member? And, many people would like us to be yes for both of those. Yes, we're a member, and yes, we're helpful. I don't think anyone wants us to be no for both of those. Where we are is yes, we're helpful, no, we're not a member. And I'm actually cool with that. Like, I can live with that. And as long as I just can continue to look for ways to be helpful across all of the situations under investigation, I feel like we're being a good citizen of the world.
Awesome. All right. Let's go ahead and open it up for questions. Protocol is as per the norm, go ahead and say your name and an affiliation if you have one, but not a lot more than that. And then if the question could be really brief, and I'll just go to the dean of the genocide community here at Stanford University. I'll tell you a story while we're waiting, Norman. When my daughter, who also the apple doesn't fall far from the tree, when she was a freshman at high school, she went to the club fair and she was walking around and said, like, do you not have a genocide club?
That's quite an introduction. My name is Norman A. Mark. I'm in the history department also here at CSAC. My initial reaction was exactly like Alan's. Wow. That was just an amazing a panoply of responsibilities. And I was thinking if you had some kind of slide that would show all of this, it would be incredibly complicated and difficult to kind of sort out. And I guess my question, if I can, a few of them, comes from that. First of all, what is the essence of international justice when it comes to Ukraine? Who is you said we support all these efforts. Is it from Ukraine itself? In other words, is the Prosecutor General in Ukraine running this process? It made me a little bit nervous when you said we're supporting them with funding, but I guess they need funding for everything. But really, what is the essence of the process? And who is taking responsibility for it, and who's going to make sure that it's seen through to the end? Now, you talked about Harris's, and these are all related. So let me see if get them in. You talked about Harris's speech about war crimes, and that there was an internal process to decide that this was war crimes. What does that mean exactly? Internal within the State Department? Do you have enough staff, in other words, to investigate? Now, I mean, the number keeps going up every day. The 77,000 war crimes. Now, I think you gave us the number. The cases of war crimes in Ukraine. Do you have the staff that actually can do that, or do you get the stuff from Ukraine and then go through all that material yourselves? I mean, be curious what that internal process was like. And there's a kind of brackets here. What about the Defense Department? This issue that they won't turn over material. I mean, are you lobbying with them to try to? I mean, is that also part of your brief to get them to share material with you? So I guess those are my questions, all related to this very complex set of responsibilities and support. I mean, you talked with Alan. You mentioned support. Well, are you leading this process, or are you one of these zillion lines that's drawing this process together?
Yeah. It's a great question. It's an incredibly saturated space right now. There's a lot of states that want to be helpful, and they're deploying experts and sending forensics teams and mobile forensics labs and offering this and that. The prosecutor of the ICC has received millions of extra voluntary contributions, and of staff and of human beings and of money and expertise, et cetera. Part of what the Atrocity Crimes Advisory Group that we created with the EU and the UK is attempting to do is to sort of coordinate some of this and to make sure we're not over-investing in some areas and then under-investing in others, so that we have visibility as to what the various donor states are doing, so that we don't step on each other's toes. But it's super difficult. And the civil society space is equally as saturated and somewhat disconnected. Every group feels like they're supposed to be doing work in Ukraine, and their donors are asking them, what are you doing in Ukraine? And how many statements have you taken? And so there's been a big effort to try and work with civil society organizations to train them to do trauma-informed investigations, so they're not asking witnesses to give 5, 6, 7, 8 different testimonies and statements. So it's very decentralized. I try not to use the word chaotic, because we are trying to bring some order to the thing. If I were to take a snapshot of the justice pathways, there really are 3. The main one is the local courts. I think it's the Prosecutor General himself is going to be having to do the lion's share of these cases. The evidence is there, the victims, the survivors, now the perpetrators, they're all there. The second is the ICC, who will take a handful of cases probably. And a division of labor that is developing is partly driven by subject matter jurisdiction. Ukraine has no crimes against humanity statute and has no explicit command responsibility statute. And so if cases are going to go up the chain of command and deal with and describe these events as crimes against humanity, they're going to have to go forward before the ICC. The third main node or pathway are domestic courts in Europe that are waiting for some of those perpetrators to start to travel, whether they become persona non grata or they decide they'd rather risk it going to Europe than fall out of a window, like others have had happen to them. There's very dangerous windows in Russia. They may be tossed out. There may be political transformation. Mike can probably tell us more about the prospects for that. But there will be cases. Perpetrators always travel, and they are always ultimately found. And so those are the 3. The fourth is this aggression issue, which I imagine we'll get questions on, but there's talk of creating a standalone tribunal for the crime of aggression. When it comes to these atrocities determinations, these are by practice and custom the prerogative of the secretary. So he will task us to determine whether or not we can use in our strategic messaging particular words, because words have meaning, and we do this very carefully. We don't just toss these words around. And each of the crimes that we might invoke have particular elements. And so we need to make sure that we see indications that those elements are satisfied. We're not a criminal process, so we're not doing this beyond a reasonable doubt, and we're not necessarily individuating responsibility, but we are opening it up to being able to use these terms. Part of the reason we did the crimes against humanity determination is I was chafing in my own public remarks, where all I was cleared to say was war crimes and other atrocities. And I kept wanting to say war crimes and crimes against humanity, war crimes and crimes. I couldn't say it because we hadn't done that internal process. So we did it. So what it involves is essentially looking at what our intelligence community has collected, looking at what law enforcement or the Defense Department will have collected, looking at what this new conflict observatory has collected, looking at what reputable human rights organizations have collected, and then looking at journalistic accounts. And all of it gets put together into an internal intra-departmental process. My office is responsible for the factual component. The legal advisor's office will then apply the facts that we find have reasonable, there's a reasonable basis to believe that they're accurate. We'll apply them as against the law. And then usually the regional desk will do the policy prerogative, which will say why this is important to do this and what we plan to do with this. How will we use this determination? And so those three processes happen sort of in parallel with each other. And then as part of the policy process, we determine how we're going to announce that. So I mentioned the genocide determination with respect to the Rohingya. Secretary Blinken did a gorgeous speech. He went to the US Holocaust Museum. They have a very special exhibit there. We all went and watched the exhibit, and then he came out and he gave remarks to members of Congress and the press and others. That's how that was done. When it came to the crimes against humanity determination, we knew that Kamala Harris was going to the Munich Security Conference. That was a different audience, and it felt like a good audience to be able to make this statement. And she delivering it so powerfully as a former prosecutor, I thought carried a lot of weight. It got picked up. I was concerned it was going to fall as a kind of nothing burger because like everyone would be like, yeah, of course it's crimes against humanity. Like, what's the big deal? Why are you saying this? It got picked up by everybody. She just did it so well, I thought. And so that's how that process works. And then finally, with respect to the reporting that the Defense Department is unwilling to do some sharing because of this longstanding objection to the exercise of jurisdiction by the court over the nationals of non-party states. Can you tell I've said that sentence many times in my career? That is still the subject of an interagency process. So we are hoping to reach consensus.
Wonderful. Okay. I have Rose here. Let me ask, are there any CSAC fellows in the room? Because I know that one of the conventions here locally is that the CSAC fellow, well, you're not a fellow, Harold. I mean, you're a deputy director, but I'll put you on the queue.
Thank you very much. Fascinating presentation. More than a tour d'horizon, it was a tour de force. So thank you very much. I'm the former Arms Control Undersecretary.
Yes.
My name is Rose Gottemuller. For those of you who don't know me, I'm currently a lecturer here at Stanford. But I'm the former Arms Control Undersecretary of State during the Obama administration, and I'm accustomed to what I call the whipsaw.
Mm-hmm.
So if the Democrats are in office, there's a great deal of enthusiasm for arms control, and things get built up, the structures get built up, and the support is there. And then when a different administration arrives in office, it all gets dismantled. Are you concerned, given what your group and the whole government interagency went through during the previous administration, that you could suffer that whipsaw effect should a different president be elected? Or is the bipartisan support you're building up, I'm very impressed with what you had to say about Lindsey Graham, is that going to cushion you from any whipsaw going forward?
That is definitely the hope, the latter. We have made a point of cultivating those relationships through our Legislative Affairs Bureau. I accept every request to come and brief staffers, members, et cetera. Several congressional delegations have gone to Ukraine, as many have followed. Several have gone to The Hague to meet with the ICC. I never thought that I would see that day, all bipartisan. We've seen many amendments now to various laws in order to strengthen our ability to play our role in the international accountability landscape. I hope that that is the case. I'm also quite cognizant that my office was gutted under the Trump administration. I am still rebuilding. I still have 4 open slots. And it's so difficult to hire, as you will remember. So that is a concern. There's only so much one can do to concretize this stuff. And the only thing I can hope is that we show results, that by virtue of engaging, by virtue of being a leader in this field, good things come of it, and that will be seen by future administrations, regardless of party, and that will be then justify continued investment in this space.
Right. Take one from to Eric. Let's go ahead and go to Eric, and then we'll take Mike, and then we'll go here in the front row.
Welcome back, Beth.
Hi, Eric. Good to see you.
Hi, Eric Jensen from the law school and CDDRL here at FSI. Yeah, I've just got to underscore the wow factor. It was quite a tour. I've got 2 questions. One is a question that I think I've posed to you in the past about traditional justice and the importance of balancing comprehensiveness, the urge for comprehensiveness, with the absolute imperative for speed.
Mhm.
And Cambodia was sort of a worst case example of just going on forever when it was basically known that these defendants were guilty, but they continued to build a historical record through legal processes, which isn't the most efficient way to do it. And I really worry, especially with Ukraine, that there'll be so much evidence. Just get them tried and convicted on one or two sure counts and put away for life, and the 77,000 lifetime sentences can follow. So I think the question of how much process is due is one that's front and center. Second, you really eloquently mentioned Ukraine as a new Nuremberg moment, and it could be, but where would it go from there? Might we look at structural adjustment, primarily getting Russia off the Security Council? I know how impossible that is, but it seems like the international infrastructure is undermining itself with having the membership of this rogue nation.
Yeah, I mean, on the latter point, yes, I agree. I mean, it's really hard to imagine the Security Council playing the role that was envisioned to play while Russia is under the control of Putin and folks like him. It's just that there's no interest in, they're just obstructionist everywhere. And so what my book is very much about is how that has forced us, to multilateralists and justice advocates and others, to think creatively about how to use other mechanisms, institutions, et cetera. So in the face of debility at the Security Council, we see the General Assembly flexing its muscles and creating institutions like the IIIM, and maybe even creating some sort of an aggression tribunal. So the result is that activity just moves elsewhere, and then we just sit and issue talking points at each other in the Security Council chamber. In terms of like your invocation of the Cambodia Tribunal, which indeed was, too slow, too late, too little justice, too expensive, the list of concerns go on. I think we have learned a lot of lessons about how to do justice in a more cheap and cheerful way. We can look at the Special Criminal Court in the Central African Republic, or I didn't even mention the Extraordinary African Chambers, which for $10 million brought justice to Chad with respect to the former dictator, Hissène Habré. It had been a long-standing sort of just, symbol of impunity for so many years. So it can be done. It can be done in ways that is much more efficient and is also still fair. So one of the main goals of the Atrocity Crimes Advisory Group is to ensure that when the Ukrainians are doing these cases, they are scrupulously fair. They're not cutting those kinds of corners, even where they may be impulses towards vengeance with respect to some of these perpetrators that are in their custody. And so part of what is there is to make sure that those international fair trial guarantees are being scrupulously adhered to. And part of the messaging is that you enjoy the moral high ground now. And don't relinquish that, because that is precious in an international community. That is what is helping to mobilize the type of consensus that we're seeing at the General Assembly when there's 141 that vote to condemn Russia's aggression, even while Russia is out there desperately trying to whip votes in its favor.
Yeah, let's go ahead and come forward, say wear and tear on your shoes. But while you're coming forward, let me ask one question that has come in from our viewers online. And I think this goes to the question about the atrocities prevention points that you referred to, and again, gets us off just our sole focus on Ukraine. And the question from Celeste Brevard is, what new efforts are being made? I'm sorry, I'm going to ask a question from Natalie Long-Merkulis. What is the Biden administration doing to prepare for future gross human rights violations in future wars? And she mentions the ones that may occur over Taiwan.
Oh. Hi, Natalie. Good to see you. Or not see you. Good to have you here. She's a former student. I am not working at all in Taiwan. I know we have created a new China House, which is meant to coordinate our focus on China. And the secretary has announced this sort of, our approach is one of both cooperation and competition, and we need to kind of keep a healthy balance between those two. The Atrocities Prevention Board that was created during the Obama era is still alive. It's been retasked as the Atrocities Prevention Task Force. They designate, and I think this is classified, so I won't mention which countries, but a handful of countries every year that are countries of high concern. And that is where extra investment will go in order to do what can be done when it comes to prevention. And this is everything from tracking hate speech, from trying to empower peacemakers, from trying to just understand the dynamics of a society and make sure that the diplomatic community locally understands what those dynamics are, trying to support local institutions that would instantiate the rule of law, that would ensure that individual minority groups are protected, they're entitled to constitutional protections, et cetera. All of that work gets done, but it's very bespoke because each context is so unique. And so that's what the Atrocities Prevention Task Force is focused on.
Okay, let's go here, and then we'll go to our CSAC fellow in the back, Mr. Trancoons.
Okay. Use the microphone.
I'm Vicki Brooks, and I'm retired staff here. So I'm also
If you could use the microphone for those
Yeah,
who are
I'm
online.
also a wow. Thank goodness for all the work you're doing and all the people behind you are doing, and for the administration, which is now being helpful to the ICC, but not a member. All those other countries that are not members that feel they're being helpful, whether they are or not, in their way, we're in a really bad club as far as I'm concerned with members that are not. And I know maybe if it was up to you, you would have us be a member. I would, that's my assumption. Maybe I'm wrong, but I think so. I think you're on my side with that. And so it's just very, it's all that perception again. You say you want it, you're doing this and you're doing this, but you're not a member. And other countries now can use this exact same um, things, exact same excuses for why we're not members. Okay, that's enough of that. Then, and so maybe just get a little reaction from you about that. And then just today, when the Mexico found more evidence about the atrocities of their own army in disappearing those students, those 45 students from the school. But that's in addition to the thousands and thousands of disappeared in Mexico. And are we, what are, is that also part of
Yeah, thank you. No, it's great. We are very much in a unique position vis-a-vis the ICC when we are not a member, but we're very supportive. And I asked the president of the Assemblies of States Parties last time I was in The Hague, I said, is there any other states that are like us, that are in this kind of weird, 1 foot in, 1 foot out kind of a position? And she sort of thought to herself, and she's like, no, not really. Like you're either not a member. There are some states that do send observers to the Assemblies of States Parties meetings. And they often use that forum to rail against us often. So when I gave our intervention as an observer state, I was squeezed between China and Iran, which was sort of awkward on the stage there. And so I gave this very positive, happy-go-lucky kind of talk, and they used their time to, basically yell at us and others around the globe. So it's definitely a sui generis sort of a position, but we're there and it's working. And so that's where we are until Congress makes the decision otherwise. In terms of the Mexico situation, indeed, I've only just now started my office to engage on the situation in Mexico, in part because you are seeing the Mexican state stepping up and conducting those sorts of more genuine investigations and exhumations, particularly with respect to those students who, I think the prevailing theory now is that they were commandeering those buses to go to a protest, and one of those buses was full of some sort of illicit substance, and they didn't know it, and they were just kind of wrong place, wrong time. Nonetheless, the local government was very clearly involved in somehow enabling that massacre to happen. And many of those remains have never been found, and those families don't have any sense of closure. So we've met with some of the Mexican authorities, and we're sort of just looking at what their plans are to address the many disappearances that have happened. And if there's a way that we can plug in, we will definitely do so. But it is relatively new for my office.
Harold?
Thank you for allowing me to use my position as a former CSAC fellow, although it's been many years. I'm actually going to ask a question for CSAC co-director Scott Sagan, who's joining us online.
Oh, great.
And Scott asks, what are the trade-offs between prosecuting the crime of aggression and reaching a possible negotiated settlement in Ukraine? How would decisions about this trade-off be managed inside the U.S. government?
Yeah, hi, Scott. It's a really good question. The Ukrainians have, from the beginning, been asking for the international community to prosecute the crime of aggression in connection with this war. They see it as the original sin. They see it as the mother crime, that all of the war crimes and crimes against humanity that have been committed have flowed from this initial decision to seek territorial conquest within Ukraine, and they see it as a gap. The ICC has subject matter jurisdiction over aggression. It's in the statute. There's a definition and there's a jurisdictional regime, thanks to this review conference that was mentioned in my introduction, in Alan's introduction to me. However, the jurisdictional regime is such that both the victim state and the perpetrator state have to have ratified the amendments, and neither Ukraine nor Russia has. And so the ICC cannot exercise jurisdiction over the crime of aggression. Now, what the prosecutor has said is that the crime of aggression will be a predicate set of facts that will be in evidence, even as he is prosecuting war crimes and crimes against humanity, because many of the acts of aggression, so acts of bombardment, acts of invasion, engagement with Ukraine's troops, etc., these could all be considered acts of aggression, are also potentially war crimes. And so he can charge them as war crimes, but the same facts will get in evidence. That is not, the Ukrainians are adamant that they want to see the crime of aggression be prosecuted. This is a crime that has not been prosecuted since World War II. It was the centerpiece of both the Nuremberg and the Tokyo trials, but it sort of went almost into desuetude afterwards. There was no dedicated treaty. They had a very hard time as they were drafting the ICC statute. The reason it wasn't included in the beginning was we couldn't reach consensus on the definition or the jurisdictional regime. So they essentially punted and they said, okay, take it up later at a review conference. We finally did reach some sort of a consensus package of materials of amendments, and those are now part of the treaty. So there's a couple of different proposals that have been put forth for how a prosecution for the crime of aggression could be done. One would be in Ukrainians' courts itself. They have a provision, or they could adopt the Rome Statute provision, but they have a provision for violations of territorial integrity or sovereignty that could be charged. It's essentially analogous to the crime of aggression. And there have been some charges that have been brought in Ukrainian courts against ordinary soldiers for participating in the war, which is somewhat controversial because the international definition is a leadership crime. It's only those individuals in a position to plan or execute acts of aggression that are prosecutable for the crime of aggression before the ICC, and that's how it was done at Nuremberg as well. So interesting that Ukraine could do it. Ukraine could do it as part of a hybrid court. If Ukraine were to amend their constitution or their local law to allow foreign judges, foreign prosecutors, maybe defense counsel, staff, you could hybridize a specialized chamber within Ukraine that would have exclusive jurisdiction or primary jurisdiction over the crime of aggression. At the other end of the spectrum, you could imagine standing up a full-scale ad hoc international tribunal, maybe through the same route that the Cambodia Tribunal was established, which is a bilateral treaty between Ukraine and the United Nations. It would be negotiated by the Secretary General. The states of the world could support this through staffing, funding, evidentiary sharing, et cetera, a whole range of ways. And it would be a standalone institution that would probably be stood up in The Hague somewhere. And there's a bunch of different models in the middle. Where we have landed is those discussions are ongoing, but the Dutch have offered to host an international center for the prosecution of aggression. This is essentially an interim step. It would be a group of investigators, mostly Ukrainian, but internationals would be included, who would start to collect evidence of the crime of aggression and of acts of aggression, and also to identify dossiers, essentially, who would be those individuals within that leadership cadre who should be charged or who could be charged with the crime of aggression. Now, one of the complicating factors is the issue of head of state immunity. And would Putin, as the head of state, enjoy head of state immunity before an international tribunal? He probably would not enjoy it before a purely Ukrainian tribunal. And then, so what happens if you've got some sort of a hybrid in the middle? Now, to the actual question, Harold, thank you, or Scott, thank you by Harold. There is, obviously, have been a number of efforts to initiate some kind of a negotiated solution to this conflict. And so far, Russia has really rebuffed all of those efforts. So there isn't an ongoing peace process per se. The Chinese have come forward with some proposals. There was a just peace resolution that was recently issued by the General Assembly calling for this, but there isn't an actual process that's underway. Ukraine has put forth its own principles, what it would like to see, and much of it is based upon their right to territorial integrity and political independence. Of course, those are the principles that are enshrined within the UN Charter. And so for any of these efforts, it may be difficult to negotiate with Putin because he could be a defendant not only before an aggression tribunal, but also we may hear before the International Criminal Court. if those arrest warrants issue and if his name is on one of those arrest warrants. So we have been in this situation, however, before. I mean, if you think about the way in which the war in the former Yugoslavia was finally resolved, there were certain individuals who were already under investigation or indictment who were just not invited to Dayton. They were not part of those accords. And they eventually became sort of excluded and neutralized even within their own system because they no longer had the ability to exercise power over those particular groups. And so those groups came to the table and then a peace was achieved without those particular individuals. Ultimately, in the end, Slobodan Milosevic was also himself indicted, even though he wasn't indicted at the time. And so, we've done this in the past. And we've seen other situations where we've held off on justice, like in Syria, where there were concerns that if we went after Bashar al-Assad too hard, the war would never come to an end, et cetera. Well, the war is still going, right? So, we can placate some of these autocratic rulers until the cows come home. But if they're not inclined to go towards peace, they're not inclined to pursue peace. So as far as I'm concerned, we should continue to pursue justice because, and if they're ultimately deemed responsible, they're deemed responsible.
I saw Director McFall had his hand raised, but while Kate, you're moving, let me ask one additional question again, which takes us away from the Ukraine theater a little bit. I was surprised to see some comments recently by Colombia's president, one of the cases that you mentioned, President Petro, suggesting that they might embrace a total peace in Colombia. Colombia and Iran are two of the countries that are kind of ones that I'm very interested in, and that they might, adopt a total peace, which would essentially seem to involve a blanket amnesty. I think this is very early days, and there have been some protests about this. So I guess my question is not so much about Colombia. If you have a position on that, that'd be interesting. But does the U.S. government generally have a position on this question of accountability? Should there be accountability? I mean, I know that we believe that if states have a try or extradite obligation under, Geneva Conventions or the genocide conventions, for instance, they have to honor those obligations. But where that kind of obligation doesn't exist, does the U.S. government say, sort of up to you to decide how to resolve this, or does the U.S. put its thumb on the scale in favor of criminal accountability or truth commissions?
Yeah, I think we put a thumb on the scale. I think there's a recognition based very much on our own history and practice, but also on empirical evidence and academic research that has been done, that societies do better if they acknowledge the crimes of the past, if they acknowledge what happened and have some sort of a justice process. And that can involve truth telling, it can involve the rehabilitation of victims, it can involve a justice component, it can involve guarantees of non-repetition and reform of institutions to ensure that they don't revert back to the past. So, for example, security forces have been disbanded, et cetera. So there's definitely an idea that something must be done. We also have pretty robust international law, and you've invoked some of it. There are treaties that obligate states to prosecute, and so states generally should adhere to their treaty obligations. But there's also law that is emerging about that limit the ability to utilize full-scale blanket amnesties. There seems to be, where we seem to be landing, and the law is still somewhat in flux here, but that conditional amnesties that acknowledge the right to victim, amnesties that have some sort of conditionality, that you only get amnesty if you provide truth, if you show where the bodies are buried, if you engage in community service, if you give back to the polity and help rebuild the polity, if you serve some sort of restriction on liberty, if you have some maybe more limited sentences. These are the types of conditionalities that Colombia is experimenting with its HEP process, its jurisdiction and peace process. So as long as victims are also rehabilitated, so that there's some measures for restitution, for rehabilitation, for satisfaction, et cetera. And I think we would support states adhering to international law as they pursue transitional justice, recognizing that they do have a fair amount of leeway. And Eric, I'm sorry, you mentioned the idea of traditional justice, and we didn't really get a chance to talk about that, but many states have relied on adaptations of their traditional dispute resolution mechanisms to deal with the commission of international crimes. So in Rwanda, you see the gacaca process. In Liberia, they have the Palava Hut process. And some of these can be quite helpful, I think, to help local communities reach a point where they can live together peaceably. We cannot force reconciliation, we cannot force forgiveness, but it is possible to create space where those sort of outcomes can be reached. And so that's what policies and practices can do. And so we try to, as my little office, provide some technical expertise here and also help our local embassies who are in close touch with officials that are designing these sort of transitional justice responses to provide some comparative examples. So this one part of the reason we're in Ethiopia, my team is in Ethiopia right now, is that there's a group coming together to talk about how transitional justice has been done around the world. Here's what we did. Here's what worked. Here's what didn't work. Don't do this. It was horrible. Try this. Maybe that'll work for you. Kind of sharing those best practices so that they can then be adapted to the local context.
I may have had, I may have imagined Mike being in the room. I don't see
He had
him.
to slip out. I think he had to
Okay,
teach.
So,
Yeah.
yeah, so that was rude to not let the director of FSI ask a question. So I'll
You'll
take.
be hearing from him later,
Yeah,
I'm
exactly.
sure.
Other questions? Yeah, right here in the front.
Thank you for the excellent talk. I'm Vikram from Gun High School. My question was regarding enforcement. I know you
Don't you have
said
to be in school today? That's okay.
field trip. I know you mentioned that you had some bodies going outside the Security Council through the General Assembly. And my question is, does going outside the Security Council procedures create a risk that justice will become unenforceable and turn into a sort of, global north versus global south, east versus west kind of dispute that makes it aspirational, even with tribunals?
It's a terrific question. And I think that your instinct is right, that without the Security Council backing, it's very hard for anything to be enforceable. So everything would have to be done through voluntary cooperation of states. And we've seen states doing this. We've seen states voluntarily cooperate with under the sort of rubric of a General Assembly resolution, encouraging them to do so. But it's never going to have the kind of power that it could have under the Security Council. At the same time, we shouldn't overstate what the Security Council can accomplish. I mean, I was at the Yugoslavia Tribunal when we had dozens of defendants who were at large. And in fact, there were photographs that would show up in the New York Times of one of these defendants or one of these suspects in the same bar as UN peacekeepers. And we're like, okay, guys, the guy's right there. Like he's at the end of the bar. Like he's very well known. Like, why are you guys sitting there having a beer while this guy's sitting over there? So even with the Security Council provenance, you don't necessarily get the kind of enforcement we would like to see, but there's no question that under the UN system, that is the case. So then it's about essentially appealing to, I think, for states, the underlying principles that are at stake here. Not only sovereignty and territorial integrity, but also the right of everyone to live a life of peace and dignity, which of course Russia has violated when it comes to Ukraine, and that the states of the global south should recognize that they too value those principles. And this is an opportunity to reinforce those principles and then ideally be able to invoke them in their own context if and when one of their neighbors tries to cross an international border in some effort to acquire territory or, for whatever other purpose. So it is really about going back, I think, to first principles. And I think it's important to remember that the Universal Declaration of Human Rights and the UN Charter, yes, those emerged during a period of time in which an enormous percentage of the globe was under the yoke of colonialism. At the same time, there were independent states from all of the various regions of the world who all agreed to those principles. And then many states, as they have become independent, have now adopted those principles as well. And so these are not just Western values, these are global values. But your point is a good one, that we can't have this be about war has come again to Europe, but rather the UN Charter and all that it stands for has been indelibly breached, and we need to all work together to fix that.
Thanks. Let me ask one question again that has come from our Zoom world. And I would just ask, Ambassador, that you leave time for one last question from the chair at the end in responding to this. Also, I should announce it just gets better and better. Lunch is available after this event out in the hallway. So stick around. But the question comes from Celeste Brevard, who asks, what efforts are being made by the IIIM to hold Assad accountable? And again, makes a reference to the slow response to the current situation in Syria with respect to the earthquake. I don't know if any of those are generate like international criminal accountability questions.
Not yet, although it is interesting that the blocking of humanitarian aid can be considered a war crime. And so under certain circumstances, that I know is being explored. The IIIM, Celeste, is very active. It has been continuing to collect information from a whole range of civil society organizations, states, et cetera, sharing that with prosecutors primarily in Europe that are bringing some of these cases. There is no international option, and that's partly why these domestic courts have really stepped up and have become the real engines of accountability when it comes to Syria. But Rose, from your world, there's sort of renewed interest in thinking about chemical weapon use. And should we be thinking about some sort of a focused accountability exercise with respect to chemical weapon use? So I was just in The Hague and I had a whole day at the OPCW, which is the Organization for the Prohibition of the Use of Chemical Weapons. We did a seminar at Leiden with OPCW principals talking about some of these proposals, including potentially a standalone tribunal, but also states looking through their penal codes and figuring out what they can do with respect to the use of chemical weapons. This is a very strong taboo under international law. And Syria, I think, maybe is the first state that is a member of the Chemical Weapon Convention that has now been determined to have actually used chemical weapons against its own citizens. So it's an extremely worrisome situation, and in order to reinforce the norm of against chemical weapon use, it's important to have a robust response to that. There were efforts. This is back to your question. There were efforts in the Security Council to create a joint investigative mechanism that had the ability not only to investigate the use of chemical weapons, but also to attribute responsibility. But that effort was subject to the Russian veto, and at a certain point, got shut down. So what happened? Well, we got creative. The OPCW and members of the OPCW worked internally under the rules of that body to strengthen the ability of the OPCW to do this work. So now a new investigative team has been created that has the same power of attribution that the JIM had had. And so again, it's about going outside of the council when the council ends up being blocked.
Last question, two parts. Did you have your remarks cleared by the department before you spoke to us today?
Yes.
Okay. So
well, I should say they were drawn from previously cleared remarks.
So I guess for the academics or for students in the room who are thinking about next step in their life, what's that like? What's it like trying to balance the desire to serve in government, but where you serve at the pleasure of the president, you serve at the pleasure of the secretary, and you implement another political actor's policies, versus speaking in your own voice as you have done so effectively and robustly as a scholar? How do you navigate that tension?
I don't mind it as much as I thought I would. I don't feel as muzzled as you can imagine one might feel, having been an academic where you have, a constant platform. I was a big blogger, so I blogged on just security, and I could just toss stuff out there and see where it lands and see what people say, and now of course I have to get everything cleared and make sure I'm articulating policy, but I'm also part of setting that policy, and I've been able to move that policy, and so that is where I think you feel very fulfilled. And I will also say that, working in government, it's that people are incredibly smart. They're incredibly committed. We don't always agree, but we inevitably get to a good place because we take so much time to reach consensus. And everything is a constant negotiation with colleagues across the different agencies, et cetera. But when we can get everybody on the same page, amazing things can be done. So it's worth the effort.
All right. A reminder, lunch will be served after. I know Ambassador Van Schaack has to head off to her next Silicon Valley meeting, but please do join me in thanking her for a really outstanding presentation.